Honorable Court of Criminal Appeals is now back in session. You may be seated.
Thank y'all for bearing with us as we switching out here. But I think we're ready. Call the next case.
Joseph Wilson versus State of Tennessee.
Good morning, Your Honors. Tara Thompson on behalf of the appellant Joseph Wilson. And Your Honors, I'd ask to reserve 5 minutes of my time for rebuttal, please. May it please the court, the state in its briefing has conceded that Joseph Wilson is entitled to post-conviction DNA testing on two of the most important items of evidence for which he seeks testing, which is the victim's sexual assault kit and the knife that was used to harm her. And as the appellant discussed in his reply, there isn't a case or controversy about these two items of evidence.
So let me stop you there for just a second, because I think even in your brief, you know, one of the issues that has to be satisfied by the petitioner is that the items exist and that they're in such a state as to be properly, that could be tested. In your briefing, you talk about this, and just from looking through the record, I think it's correct. The knife was sent back to the jury, correct?
I believe that's true, Your Honor.
Okay, and you're asking to have touch DNA done on this knife?
We're asking for the knife to be examined to determine both touch DNA is potentially something that could be sought on this knife, but also to look for bodily fluids that may be on it.
Okay, but one of the main things that you were talking about was touch DNA, and it seems to me that this knife, you know, and this is the thing about DNA I think people sometimes overlook. You can't tell when DNA was deposited on a knife. You know, was it contemporaneous with the crime or was it sometime afterwards? And if this knife has been, you know, it doesn't, there's nothing in the record said this knife was preserved in any way to keep it from being contaminated. And then you have the jury possibly, because the record's silent, whether they open the package and are handing it around or something like that. If you get some stray touch DNA on it that is unknown, that doesn't really say that that's the real perpetrator. It could have been someone who handled the knife.
So, and I think to piggyback onto what Judge Campbell's asking is, you know, just because the state at the trial level conceded they had it and it was available is not necessarily a determination that it's in such a state that it can be tested, in that it hasn't been contaminated some other way. And I agree with you, the state's conceded that here on appeal, which we're gonna ask them the exact same question. There's no, where's the proof to show that it can be tested in such a way that it hasn't been, that we know that it hadn't been contaminated?
Well, a couple of things on that, Your Honor. The first is that there is testimony from the expert at the evidentiary hearing below about this contamination issue. As Judge Campbell said, the knife went back to the jury, but there's every indication from the record that it went back in a sack. And so,
But even your brief says that you can't say, there's no instruction from the judge saying don't open the sack. And there's nothing from the jury to say that they didn't open the sack. So it's speculation. What we're talking about is speculation about did they open the sack or not. That's the question I have.
well, our argument doesn't depend on whether or not they opened the sack, because I agree with the court that if what Mr. Wilson was coming here to say was, if you find any stray male DNA on that knife that's not mine, I go home, that we would have a problem. But this court under Powers has to presume the most favorable, realistically possible test results. And those results in this case on this knife and every other piece of evidence is to get a CODIS profile that identifies whose profile that is. And
That's assuming somebody's in CODIS.
it is, but the court has to presume the most favorable, realistically possible test results, and that's realistically possible here, that the perpetrator of this terrible crime against this woman, which was a violent assault, is in CODIS for something else. That's something this court should presume. The court should presume that the DNA on this knife is not going to be a juror's, and it's not going to be a random profile. It's going to be a profile that we can identify. It's also important that in this case, the police collecting the evidence did such a great and thorough job of collecting evidence related to this case, because it's not just the knife that we're asking to test. And another theory and another way that this court, that DNA testing could present realistically possible test results that would change the outcome here would be a profile, a male profile on this knife and on other pieces of evidence that never went back to the jury, that there's no question of whether or not the sack was ever opened. Because as we argue in our brief, that theory of redundancy would also show that there's a male DNA profile on this knife that matches other pieces of evidence. And that would also say this isn't a random profile, but the profile of the assailant.
Speaking of the other pieces of evidence, the question I had, and I apologize if it's clearer in the briefs than I think it is, but these other pieces of evidence, were they that were collected, were they actually introduced at trial? And
The 18 items.
yeah, were those items actually introduced at trial, or were they just pieces that crime scene collected, as they should have, as they're doing a thorough investigation, but no one ever actually introduced them at trial, so the jury would have never seen them, they were never tested, any of that stuff?
There's no evidence from this record that the other items that we're seeking to test went back to the jury. The victim's underwear, her robe, her pajamas, there's every indication that those have been preserved. And that is, again, an issue that the state conceded below. So there isn't a record on this because the parties were in agreement.
But were
that
they ever introduced to trial?
Were those pieces of evidence actually introduced at trial? I understand what you're saying, they weren't necessarily sent back to the jury, but evidence can be introduced and not actually sent back to the jury room for them to handle or look at, or however you want to say it.
I can consult the record and confirm for the court specifically what evidence was and was not actually introduced as evidence at trial. I believe that some of the victim's clothing was referenced at the trial as an exhibit, but there's no indication that it was removed from packaging, that it was handled. The record doesn't reflect that for these pieces of evidence.
Okay.
It is the appellant's contention that, given that there's not a case or controversy about the knife or the kit, that this court should grant testing on that. I appreciate the court's questions that it still has an issue to decide about that. I do want to focus my argument on these other items of evidence for which we have disagreement, but if the court has other questions about the knife or the kit before I move on, I want to make sure that I answer those. The kit is the most important piece of evidence here to answer the question of who sexually assaulted this victim. The knife is incredibly important as well, but these are not the only important pieces of evidence in this case to test, and they're not the only pieces of evidence that have the potential of showing who the real perpetrator of this crime was.
So let me ask this question, though. Let's say you test the knife and the kit, and there's a different hit. There's no question that the defendant was present.
We disagree, Your Honor. There is absolutely every question in the universe that Mr. Wilson was present at this crime.
I thought he at least admitted he was part of the group, but denied that he assaulted the victim at all.
Absolutely not, Your Honor. He presented multiple witnesses at this trial who testified that at the time this crime occurred, he was elsewhere. And he testified himself and denied having anything to do whatsoever with this crime.
Okay, because because my point was, do we not have a criminal responsibility issue? But if the proof is that he was, or at least his proof is he wasn't there, then move on. I'm sorry.
This is not a question of who was present and who did what. Mr. Wilson has always maintained he had nothing to do with this crime and was not there.
Okay. But all of his co-defendants put him there.
His co-defendants do testify and say that he was present. And this goes to the issue of what's really the dispute between the parties in this case, because the parties agree that Powers controls, that Powers is the relevant standard here. And under Powers, what this court has to do, as I said a moment ago, is to determine what the most favorable, realistically possible test results are from the DNA testing that Mr. Wilson seeks, and then determine that question of whether the testing creates a reasonable probability that he would not have been prosecuted or convicted. And Powers defines that reasonable probability as whether these results would undermine confidence in the verdict. And so I appreciate the court's question, because every person who's going to be coming to a court in Tennessee and asking for post-conviction DNA testing is going to be a person who's convicted. They're going to be a person where the jury heard evidence and said, on the basis of that evidence, I find the proof beyond a reasonable doubt that you did it. Mr. Wilson is actually in no different situation from anyone else in that respect in terms of asking for this testing. But what Powers says in thinking about that reasonable probability question is that that's a probability that's sufficient to undermine confidence in the outcome, undermine confidence that he would have been prosecuted or convicted. And we actually cited multiple cases in our briefing, Your Honor, where the evidence against the person seeking testing was frankly stronger than it is against Mr. Wilson. And those are cases where people were granted post-conviction DNA testing. I mean, in the Haddix case that we cite in our brief, for instance, 2 witnesses said the defendant is the person who did this. They testified him against him at trial. That's really no different than Mr. Wilson's case. And the court in Haddix said the DNA testing would be sufficient to show that those witnesses aren't telling the truth. And they gave that person DNA testing. In Mr. Wilson's case, you have 2 co-defendants who testified, who got deals in exchange for their testimony, and who conveniently said, I was present for a terrible crime, but I didn't have anything to do with that. The person who really hurt this victim is this kid, 16-year-old Joseph Wilson. He's the one. And you do have the victim identifying Mr. Wilson at this trial. There's no question that she did that. We've explained at length in our brief why, with all due respect to her, she wasn't wearing her glasses. She did not get a strong chance to look at this person given the way that the assault occurred. She didn't identify Mr. Wilson until a court proceeding a long time later, and she said that she'd probably already seen him in the media at the time that she identified him. So that evidence is out there, but there's still no question that with that testimony, if Mr. Wilson got what are the most favorable, realistically possible DNA test results from this evidence, that those forensic results would be enough to overcome this other testimony, and that there would at least be enough evidence from those results to undermine confidence in the verdict. That's the standard, and that is a standard that Mr. Wilson has met here.
So let's move on to the 18 other pieces of evidence. The state's argument is, okay, yeah, we'll give you the knife and the rape kit. We agree with you on that. But these other pieces of evidence, they're not helpful. Paraphrasing, obviously. So why do we need to test those? If you get the knife and the rape kit, why do we need to order testing of everything else?
Well, the state says that, I think the phrase that they use in their brief is that it's too attenuated. And with respect, that's just not true here. The core evidence that's in that other category, besides the knife and the kit, are clothing that the victim was wearing during this prolonged, forceful, lengthy assault where the perpetrator had significant forceful physical contact with her and raped her. That's her pajamas, her underwear, her robe. We know that the perpetrator pulled the victim's pajama bottoms and underwear off of her as part of the assault. In her own words, she was manhandled. She was thrown around this bathroom by the perpetrator who forced her onto the ground, who assaulted her. There's a lot of touching that happened with that evidence. And we have testimony below from the expert at the evidentiary hearing who said, given that amount of contact, DNA was transferred. That was her testimony. When you have this kind of forceful contact, DNA is transferred, and that's DNA that can be found and tested using modern DNA testing. We also have the ligature, which we know that the perpetrator tied around the victim's hands, and there's also every reason to think touched more during the course of this assault because of the way that the perpetrator was handling the victim. Now, it's true that we have some question about which of these towels and slips that were collected are the ligature. Although the police did a really good job and a thorough job of collecting evidence here, it's not clear which of these towels is the one. And that's why we're asking for testing on, these other items that were present to try to determine which of these was the ligature. But it's realistically possible that the assailant, touched these other items of evidence during this assault, and that's the standard. This assault takes place in a really small bathroom. There's not a lot of space. It's lengthy, there's a lot of physicality that's happening with this assault, and there's every reason to think that the perpetrator touched those items, whether one of them is a ligature or the others are simply items that were present in this bathroom.
At the end of the day, doesn't it all come down to the kit? I mean, if you get the kit tested, and the kit comes back as a positive hit for the defendant, it really doesn't matter what DNA is on anything else at that point, does it?
Obviously, the kit's the thing that we think will cut to the chase here, but Mr. Wilson shouldn't be denied testing on other items.
But I mean, my point is the state's conceding the knife and the kit. And really, at the end of the day, especially the kit, if it comes back the kit comes back as not a hit for the defendant, that's pretty good. If it comes back as a hit for the defendant, all this other stuff's really not relevant.
We don't know what that's going to show. And what I would say is that the statute speaks in terms of what's possible. It doesn't say you get your best item and everything else gets to wait. We don't know what that kit will show. And so Mr. Wilson shouldn't be essentially punished because there's more relevant forensic evidence there. And what I'd say about this other evidence too, just to remind the court, since we're talking about the record, none of these other items have even had a screen for bodily fluids. That was never done. And that's obviously one of the very first things that would happen today. And what the expert said below, you do for starters with any of this is literally just look at it and determine if there's bodily fluids on it. Because if there are, that evidence is just as important, just as relevant as the sexual assault kit, if not more so. That's never even been done. That's part of DNA analysis that is contemplated by the statute to even take that first step. And there's no reason in a world where Mr. Wilson is entitled to this testing, where he's here asking for it, not to take that step with all the relevant evidence right now and look at it together. Otherwise, that goes against the principles of economy, and it goes against the principles of giving Mr. Wilson his best chance and his most immediate chance to reverse a wrongful conviction, which is to have access to the testing he's entitled to under the statute right now.
I know you're into your time, but I think following up on Judge Dyer's question, the other items, would you agree with me, would become more relevant depending what the kit showed?
I think that's true, and partly that's because we don't know anything about what they contain other than having the testimony from the expert that if under the facts of this case, these are items the perpetrator had significant contact with, which we do know from this record they are, then we'd expect to find DNA there. And it's certainly going to be more probative if the kit for some reason doesn't show anything or the knife for some reason doesn't show anything. But these items of evidence are all part of the puzzle here. I'll yield the rest of I'll reserve the rest of my time. Thank you, Your Honors.
Good morning, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. I'll jump right into what you both asked Judge Dyer and Campbell. The reason that the state didn't argue this is because below the state stipulated that the items, including the knife, were still existed and were in a state that could be tested under prong 2 of the post-conviction DNA statute, and the post-conviction court made a finding that that was the case. Okay. The evidence, there's not a lot of evidence in the record, so the evidence simply does not preponderate against that. If this court wants to dive deeper and say that the evidence does preponderate against it, the state would have no problem with that. But based on the stipulation and the factual determination by the post-conviction court, we felt that we could not argue against prong 2.
So why the objection to the rest of it then?
Because even under Powers, those items, even if we assume that there's a hit on someone else, that would not lead to a reasonable likelihood that the outcome of trial would change.
Well, but so to defense counsel's argument, though, I mean, some of these items haven't even been tested for bodily fluid yet. So, I mean, we may look at them, and it takes 5 seconds to realize, well, there's no bodily fluid, we don't need to test this. But some of them might, and, under Powers, if he is entitled to the best possibility, aren't those items relevant?
Respectfully, no, Your Honor. There's 2 reasons why. One, Your Honor submitted that it would take 5 seconds to screen. The defendant's asking for an analysis of touch DNA on these items as well. Like the defendant wants full screening on all of these items, so it would take more time, it wouldn't be as simple as that. But 2, and I think what's more important here is that in this court's opinion on direct appeal and in the record, the victim, when she was sort of being taken out of her bedroom, she saw someone in the bathroom. So there is a different person who is in the bathroom. So even if we assume that there is bodily fluid and that it strikes on somebody else, on these towels or these bath mats or all of these different things, that doesn't say that that's the perpetrator. In contrast to what the reason the state conceding with regards to this rape kit and to this knife is that if it hits and we have a known identifier whose DNA shows up in this rape kit, that's at least creates a reasonable likelihood that the jury would change its verdict, which is the standard under the DNA Analysis
Were
Act.
these, and I'm going through the record, I couldn't figure out if these items were ever introduced at trial.
My understanding, and again, the record is more accurate, and this court would probably need to take judicial notice of the appellate record from the direct appeal. I believe the clothing was included in the rape kit that was at least introduced. I don't think the other items were.
I'm talking about like the towels and stuff like that.
I don't think that they were introduced. I'm not positive about that. But again, the record is just more accurate than that.
And wasn't, from the testimony of the expert called by the petitioner, when asked about these other items, it seemed to me that the testimony was more speculative about whether or not anything, because nobody really knew what items really applied. It was just, everything was just collected without the speculation on whether or not it would have any value or not.
I don't think there was any testimony about the value of it at all. The speculation, I think you're correct, is that this expert was essentially opining that if somebody came around and touched it, if the perpetrator or anyone else, as the state would submit, touched this towel or, rubbed up against this bed sheet or whatever, then that had the potential and likely would leave touch DNA. That was my understanding of the expert's testimony, is that if you rub up or touch up against something, then you would leave touch DNA. But again, the reason why these other items simply don't need to be tested is because of just how I don't want to say seem flippant, but just how irrelevant that is. When there's another person who has been positively identified as being in the bathroom, and these defendants, touch DNA can go from one person to another. Like even if we presume under Powers that with these other items that there's a positive hit on them, that would not lead to a reasonable likelihood that the jury would return a different verdict. It does not undermine confidence in the outcome in the same way as a positive code match of someone on the rape kit for this victim.
Well, it might undermine the confidence in the verdict if, let's say, the rape kit comes back inconclusive, and there's someone else's DNA is found all over the bathroom, or the items from the bathroom, that's not the defendant. That would undermine the verdict, would it not?
The state would submit no, but also I think it's important to look at when we're looking at the DNA Analysis Act, we don't get to sort of accumulate all of the different pieces of evidence. We're looking at each individual piece of evidence for whether it deserves DNA testing. But even if that's the case, even if the rape kit comes back and is inconclusive, even if there's still another person, the state would submit that wouldn't change the jury's outcome, especially when you have, as you pointed out, Judge Dyer, both co-defendants very clearly identified the petitioner as not only being physically present, but as being the individual who committed this heinous act, and provided quotes and talked about his their knowledge of his affiliation with this knife and what he went on to do with them, and again, the victim positively identified the petitioner. So, again, if you're looking at, I think you said, Judge Dyer, that the rape kit's kind of, if that's there, then that's there. But with these other pieces of evidence, when you're weighing it, the jury, that would not tip the scale for the jury, is the state's submission.
And the knife was recovered at a different scene, is that correct?
It was recovered at a different scene.
It was like a burglary attempt or something like that?
Yeah, so there were two break-ins that night, and the first break-in is to this victim's house, and this victim is present, and all the interactions and all the offenses happen there. They leave in that victim's car, go to a different house and break in, and the knife is used to cut a screen before they break into the house. That victim was not present, comes home a little bit later, says, I've been robbed, calls the police, and as they're searching, they find the knife. And the knife has this victim's blood on it, which is how they identify it. But, unless this court has further question, I mean, the state's conceding that the rape kit and the knife, when you look at it under Powers, which requires that we presume the most favorable outcome for this defendant. And if we presume that for the knife and the rape kit, then there's a reasonable probability that the jury would change its outcome. But for these other items, the state simply submits that that's not the case. And so we ask this court to partially reverse and order testing for the knife and the rape kit, but affirm the denial of DNA analysis for all other items. Thank you.
Thank you, General Warren. Ms. Thompson, you have the balance of your time.
A couple points I want to address and clarify in addition to responding to the court's questions. The appellant did make a motion before this hearing to have the trial record considered as part of the record for this appeal. And my memory of that record is the same as the state's, that some of the clothing may have been exhibits at that trial, but there's no evidence any of it went back to the jury or was handled. But I don't see any evidence in that record when I reviewed it that these other items were ever something that was handled as part of the trial.
Yeah, my understanding was, I think the rape kit contained like some of the clothing of the victim, like the panties and things like that. I was concerned about these other items you want to test from the bathroom, and I just didn't ever pick up that they had been introduced.
That's my understanding as well, Your Honor. Okay. And the other point that I wanted to make briefly about the knife is the point that the state ended on, which is that this knife had the victim's blood on it. So we know it's the knife from this crime, but more importantly, it's difficult for me to envision a situation where a jury is handling a knife that's got blood on it. But I don't know, to the court's point. We weren't there, we can't know. And it is why these other items of evidence actually do become important. And when the state said, well, you don't get to accumulate those items of evidence in this consideration, with respect, the statute doesn't say anything about that. It simply says to look at the testing that someone is seeking and to assess, considering the most favorable, realistically possible results, what outcome that would have. And here, under that test, the most favorable results are to have a corresponding profile across multiple items of evidence. The law actually instructs the court to consider it that way, and there's no reason for the court to do a piecemeal analysis when that's not the request that's before the court. The other point that I want to raise and just touch on in rebuttal is that, the court has asked some questions of Mr. Wilson, and the state referenced this, and obviously the lower court really took issue with the fact that the expert that testified for Mr. Wilson was talking about, possibilities. And even some of the court's questions to me today has been about what's possible. But with respect, that's what the statute talks about, is what's possible. I mean, the Supreme Court in Powers actually said that this kind of testing, and I'm quoting from Powers, invariably involves some conjecture. Nobody can know until we do the testing. And that's really why the expert below, even in talking about these other items, was talking about what's possible, because until we do the testing, we can't know. What's relevant under the statute is to think about what is realistically possible. No one can come to this court and, ask for testing where there's no realistic possibility it's going to matter. But again, with respect, that is not the situation here for Mr. Wilson with any of these items of evidence. The, items that we agree on with the state, the items related to the victim's clothing where we know there was physical contact with the perpetrator, and the other items where there's still some question. We're in the realm of realistic possibility for all of this evidence, which is why Mr. Wilson is asking for it to be tested. He is asking for both testing to screen for biological fluids, as we discussed, and to look at touch DNA testing for those items too. Candidly to the court, what Mr. Wilson envisions is sending this evidence to a lab for the lab to conduct the testing that they determine is appropriate. And whether touch DNA testing will be possible on items of evidence where there's less clarity about where exactly it was touched, we can't say. But we know that the perpetrator pulled this victim's clothes off, and that's an excellent place to look for touch DNA, for instance. And what happens, the ligature is another item of evidence where that's relevant. But for these other towels, what we're going to be looking for.
That was going to be one of my questions is, and I know I'm oversimplifying it, Mr. Coleman made that very clear, but, testing for bodily fluids, you're looking at a towel, they can see that relatively quickly.
Right.
But for touch DNA, they would actually have to examine every inch of that towel in order to determine whether there's somebody else's DNA on that towel, because we don't know where the towel was touched.
That's right, and that's not, Mr. Wilson is not asking this court for an order, lab, swab every inch of every.
My point is that takes us back to, why are we testing a towel that no one can say for certain it was touched by anybody or used in any way, because, again, you're looking at a normal-sized bath towel. That's a big piece of evidence to look for touch DNA on when there's no proof that anyone ever touched it to begin with.
Well, for starters, they should be screened for biological material. And to go to the state's point about that, there's no evidence, there is some evidence that the victim saw someone in her bathroom, but I don't think she saw someone in her bathroom touching all of her items or doing the kinds of things that would leave their bodily fluids in her bathroom. This is
Speculation is that, because, again, touch DNA, if they come up against something, even if they didn't intend to, it could leave touch DNA. So whether they intended to or not, the whole point of it is you could leave it behind. So if they were in the room, there's a possibility, again, that they touched something and left DNA behind. I mean, that's, and going back to what Judge Dyer was saying, and again, when I think of possibility, I think a reasonable possibility. And when you start saying we're going to test all these towels, to me, that's not realistic, because, you know, you're talking about having to conduct hundreds of tests on a piece of cloth, because they take little cuttings and do all that. It just doesn't seem realistic unless you have a stronger indication that this was in fact evidence of the crime and not just some ancillary thing that was found in a particular room.
Even though I'm over time, I'd like to
Yeah,
answer the court's
please,
question
go
if I could. So I agree with the court. And what Mr. Wilson, again, is what he is asking is not that this court enter an order directing that touch DNA analysis be conducted on all these towels. What Mr. Wilson is asking for is for the court to enter an order for DNA testing to be conducted by a lab and to follow the lab's recommendations about what to do. Because the lab would certainly recommend, for starters, that setting aside the victim's clothing for a second, but I'll come back to that these towels be evaluated to determine if there's bodily fluids on them, because that should be tested. Whether the lab would recommend, to go to the court's point, that many square inches of fabric be tested for touch DNA, candidly, probably a lab wouldn't recommend that. The victim's clothing is in a different situation, though, because we do know that the perpetrator handled certain areas of that, and Ms. Nasir did testify below with her specific recommendations about that clothing to swab the areas where that clothing would have been handled for touch DNA. That's a different situation, and that is something that we'd be asking for. But what we're asking the court to do is to send this evidence to a lab to follow the lab's recommendations. The statute speaks to this kind of testing going to an accredited laboratory, and the laboratory that the parties didn't have a disagreement on below, Bodie Laboratories, would make a recommendation for testing, and that should be followed. Mr. Wilson doesn't want to waste anyone's time. I mean, frankly, he has a stayed petition for writ of coram nobis that he's waiting to proceed on until this is done. It's not in his interest to waste his time, waste the court's time, waste the lab's time. He wants testing that's going to lead to results, and that is what he's asking for from this court. So for these reasons, unless there's other questions, we do ask the court to reverse and remand with an order directing the forensic testing that Mr. Wilson seeks be conducted. Thank you very much.
Thank you. Call our next case, please, Madam Clerk.